Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. Glad you could join me today. We have lots of different subjects on estate law and estate planning. In this particular episode, I'd like to talk about the international will. In California, there's actually a few different kinds of wills that you could make, but one of them in particular is known as the international will, and basically those are for people who live inside California but will move out, or people who are currently outside of California and will move in. Okay, obviously, if you're never going to touch the state of California, then this isn't important for you. Or if you're going to stay in California until the day you die, then this also is not really important for you. But if you are going to move and be in different places, you should listen and see if this particularly applies to you. And if it does, go ahead and give me a call. I'll be happy to give you the initial free consultation to let you know if it does apply. Now, California has adopted the Uniform International Wills Act, which means it is a party to this particular type of will and does allow it. And the will, if it's done properly, will be valid in California regardless of the place it was prepared, the location of the assets, where it is that you live, okay, the testator's domicile, residency, or nationality. So it's very flexible in that regard. And if you're not going to have a living trust, and you're just going to have a will, and you come from and moved all different places, then certainly this is one type of will that you should consider doing. Now, basically, the obviously the will has to be in writing. It actually need not be written by yourself. It may be written, by the attorney if it's necessary, of course. And if you agree with it, it can also be written in any language. Okay, it can be written by hands or any other means in which it can go on paper. So hands, computer, whatever, and by any language. It doesn't have to be in English. Okay, it can be in Arabic, Tagalog, Spanish, whatever it is that your primary language is. Now, in addition to that, of course, the person making the will, the testator, of course, needs to know the contents of the will itself. Okay, obviously, if someone else is making it and says just sign here, that's not going to help. You, the testator, must know what the consequences are, and what is included in the particular will itself. Now, of course, one important fact with all of these types of wills and trusts is the executing of it, and what needs to be done in order to make it legal. Okay, so of course there should be two witnesses that are actually in your presence at the time that you sign it, in order to basically that they can verify that they were there, they were present, they saw you sign it, because obviously we don't want to have somebody else signing your will, and obviously we want to make sure that, especially if it's in a different language, that it was you that signed the particular will. And of course, if you are unable to sign, then in the absence of your signature, that doesn't affect the validity of the will. There's different jurisdictions in California that say you can put an X, or somebody can put an X for you and basically sign on your behalf, which is different than a witness signing. But all that can be done. So unfortunately, but the reality is some people make wills when they're on their deathbed or when they're 90 years old and they have lots of trouble doing things. That can all be done if the execution of the will is all done properly. Okay, um, so the international will, if it is invalid in certain parts, it doesn't mean it can't be considered to be another type of will in California as well, if it ends up going to litigation. So you want to also make sure that the signature is placed at the end of the will. Obviously, if it's placed somewhere before the end, then anything after the signature will be questioned whether or not you actually knew it was there at the time, whether you agreed with it. So do make sure that the signature is at the exact end of the will, and that the date is the current date that you're signing it. If there's no date on it, then that might also make it difficult to determine when it was signed. If there's, for example, a codicil afterwards, whether that codicil predated the signing of the will, whether it applies to that will. So make sure that, of course, it's properly signed and dated, and that the witnesses are, their lines are below the signature line. Now, you of course want to keep it safe, so that, basically, if it does need to come into play and you do pass away, that the person who is entrusted as the executor of the will be able to obtain it and do what's necessary in order to, if it needs to go to probate or whatever it is, to proceed forward. Now, if you need to revoke this will, the normal rules apply to the revocation of the will, the international will. And by revoking, that means that once it is revoked, that there is no more will as far as that particular will applies. Normally, people will revoke a will if they're either making a new one with completely different provisions, or if they decided to get a trust. Okay. Keep in mind that the validity of this will is under the conformity of the rules with the Uniform International Wills Act, and that's what governs whether or not it will be applicable, and whether it will proceed without problem and without issue. So, of course, if you like the video, click subscribe and like, and then also, if you would like to get a free consultation, you can come into my offices for one free consultation, either in Long Beach or Los Angeles, and you can also email me, and also, depending on the circumstances, once my office is retained, we do make house calls, basically, because a lot of our clients are elderly and unable to proceed by themselves. Okay, more in the coming videos.